Hello, my name is Richard Owen from the University of Glamorgan. In this lecture we're going to be looking at restricted duty situations. So we've already looked at the existence of a duty of care and the so-called neighbour principle and the three-stage test, that you have a duty of care to whoever in law is your neighbour, someone who's directly and closely affected by your acts, and the current three-stage test for deciding who is your neighbour, which is that there must be reasonable foreseeability of harm, close proximity between the parties, and it must be fair, just and reasonable to impose a duty. And these three considerations are taken together and not separated out. And in certain types of situations, they look for more requirements before they'll say there's a relationship of proximity between the parties. I'm going to start by looking at economic loss, because the situation when it comes to economic loss is that the courts will not allow for a loss of profit. They'll only allow for an economic loss that's consequential upon physical injury. And if we start with the case of Spartan, Steele and Martin, now in that case, the electricity was negligently cut off by the defendants to the claimant's factory, and they had to throw a lot of molten metal away to stop it solidifying in furnaces, which would have ruined the furnaces during the period of the power cut. And they were allowed to claim for the loss of profits on the molten metal that they actually physically had to throw away, but they also claimed for the loss of profits that they would have made on runs that would have occurred during the period of the power cut, which was some 16 hours or more. And they weren't allowed to claim for that what's called pure loss of profit, which wasn't consequential upon physical damage. Now, what promised to have a big impact in this area was the ANS test. At one time, the two-stage ANS test was being enforced. Of course, the first stage of the ANS test was there a relationship of proximity between the parties? The second stage was there a policy reason for withholding a duty of care? And the ANS test was meant to be a general principle, applying all types of situations, and was not so respectful of existing categories as previous tests and the existing tests had been. So in the case of junior books and Vetchi, a floor had been negligently laid by subcontractors in a factory and had to be relaid. Now, applying the ANS test, they were allowed to claim for loss of profits during the period when the factory had been out of action. And so the ANS test radically extended duties in the area of economic loss, or at least promised to do so. The case of junior books and Vetchi has never been formally overruled. Unlike the case of ANS, it's never been formally overruled, but the general orthodoxy is it is now confined to its facts. And we appear to have gone back to the same type of situation as existed before the ANS test, where we look at existing categories and there aren't allowances made for what's called pure loss of profits. So if you take the case of Muirhead, an industrial tank specialists, here was lobsters were being kept in a tank and the electricity supply was being affected again. It was possible to claim for the profit that would have been made on the lobsters that were killed, but not for the loss of profits, which was unrelated to physical damage. So it's very similar in its facts to the Spartan Steele case. Now, one area where it is possible to claim for economic loss is for so-called negligent misstatements. And this starts with the case of Hedley, Byrne and Heller. Now, under this case, the claimants were an advertising agency and they wanted a bank reference on a client to make sure that the client was creditworthy. So they got a credit reference, which was a favourable reference from the defendants, who were the prospective client's bank. Unfortunately, the negligence had been negligently given. A key fact was that it was a disclaimer was put on the reference that the bank would not be liable in the event of any negligence. Turned out that the clients weren't creditworthy, and the claimants lost a significant amount of money and sued the bank for their negligent reference. I say the key fact in that case was there was a disclaimer of liability, because obiter, the court said, where there is an assumption of responsibility, then there can be liability for economic loss. But in this case, there had been no assumption of responsibility because the bank had disclaimed any liability. However, what you've got to remember about the Headley-Byrne case, it's an old case from the early 1960s, and it predates the Unfair Contract Terms Act 1977, and we're going to see that the Unfair Contract Terms Act 1977 in later cases seems to have had a significant impact when it comes to this idea of assumption of responsibility. Now, in a recent case of Customs and Excise Commissioners and Barclays Bank, it was held that there was no assumption of responsibility. The Customs and Excise obtained freezing orders against various companies, and they notified the defendants that there were freezing orders on their clients' accounts, and payments should not be made out of these clients' accounts. After they'd received notice of these freezing orders, the clients paid out substantial sums from their accounts. And so Customs and Excise sued the bank under the principles from Headley-Byrne, but was held in this case there was no assumption of responsibility. The bank had not assumed responsibility towards Customs and Excise. And some of the comments the judges made in that case, they said, well, the difference between this case, Customs and Excise and Barclays Bank, and other similar cases was that the bank hadn't actually agreed to do anything in this case. You'll remember in Headley-Byrne, the defendant bank agreed to give a bank reference. We've seen other cases where former employers have given references to prospective employers. That's been regarded as an assumption of responsibility. There's been some positive act, whereas in this case they were just told to refrain from allowing payments out of the account. So there was no assumption of responsibility in that type of case. Now, another requirement you must look for before there can be regarded as proximity between the parties, before there's been an assumption of responsibility, is that it must be considered advice. Now, initially in the Everett case, the Privy Council said there could only be liability where the advice was given in the course of a business. That was modified slightly in the case of Esso Petroleum and Marden. Someone was buying a petrol station, wanted some idea of turnover, and was given the wrong information. The defendants argued that they were not in the business of giving advice, but it was held that they were liable under Headley-Byrne principles because they had special knowledge compared to the recipient of the information. For many years it was thought there could not be liability for advice given on a social occasion. That was revised by the case of Chowdhury and Prabhakar. In that case, the claimant asked her boyfriend, the defendant, for advice before buying a car. It was wrongful advice, and she lost money as a result. But it was found that she could succeed on Headley-Byrne principles, even though it was made on a social occasion. However, what's important to remember is it must be considered advice, and not very often advice given in a social occasion will not be considered advice. If you ask for off-the-cuff advice at a party or whatever, someone will not realise the importance you're attaching to the advice that's given, then you're unlikely to succeed on Headley-Byrne principles. Now, another thing you must bear in mind before deciding whether or not there's liability under Headley-Byrne principles is the purpose that the advice was given, because you can only rely on it for the purpose for which it was given. So given the case of Caparo and Dickman, now in that case the claimants were shareholders in a company. As shareholders in a company, they were entitled to receive annual audited accounts in that company. They received annual audited accounts in the company, but they used it as the basis of an investment decision to take over that company, because the accounts showed that the company was making a profit. So on the basis of these accounts, they launched a takeover bid. It was found that the accountants had wrongfully audited the company, and instead of this target company making a profit, in fact it had made a loss. So the claimant sued the defendants under Headley-Byrne principles, but they could not succeed. Now the reason they could not succeed is they said although they were entitled to receive these accounts, they were entitled to receive them in their capacity as shareholders, as a specific purpose under companies legislation, why they've received these accounts, and that's to inform them as shareholders as to the management of the company. And so, on the basis of the accounts, they would make decisions as to whether or not to replace the directors. But they had not used this information for that purpose. So instead of using it to inform a decision as to the management of the company, they'd use the accounts to inform a decision as to an investment decision to take over the company. So therefore, they could not rely on it. Which brings me on to the next point, which there must be reliance on the statement. So the recipient of the statement must have relied on it to his or her detriment, which brings us on to the case of Smith and Bush. Now the facts of Smith and Bush was that the claimant wished to take out a mortgage to buy a property. As a condition of the mortgage, she had to get a valuation done, and it was known that the valuation would be shown to her. It was also known by the valuer that she would rely on the valuation to decide whether or not to purchase the property. She was not in a contractual relationship with the valuer because the valuer's contractual relationship was with the mortgage company, but the valuation was done. She paid what the valuation said the property was worth, but it turned out there were structural problems with the property, so it was worth a lot less than was first thought. She lost out as a result. There had been a disclaimer in the valuation, but since Headley-Byrne, between Headley-Byrne and the Smith and Bush case, the Unfair Contract Terms Act had been passed. Disclaimers would now have to be reasonable, and it was held that the disclaimer was not reasonable, and it was held that she was in a close relationship with the valuer. In the words of Lord Templeman, the relationship was akin to contract. So it had all the features of a contract other than a contractual relationship. She was paying for particular services. It was known that the valuation would be shown to her and so on. So it was akin to contract. If we think back to the Customs and Excise and Barclays Bank case, they said in that situation the relationship was not akin to a contract because they were just simply served with court orders, freezing orders, which they had not abided by. So that was not akin to contract. So relationship of reliance, a close relationship, such a close relationship that it was akin to contract. Other examples of negligent statements relied on by third parties. Another case of Spring and Guardian Assurance. The claimant had been employed by the defendants, asked the defendants to give a reference to a prospective employer, which they did so, but they did so negligently, and the claimant lost out on the job that had been offered to him, and that was held to fall within Headley-Byrne principles. Now, if we look at other types of special relationship, we look at the case of White and Jones. Now, here again, there was a special relationship with an assumption of responsibility, but it was not for a statement as such. The facts of the White and Jones case were that the claimants had at one time fallen out with their father, who had cut them out of their will. Shortly before the father died, he was reconciled with his daughters. He instructed his solicitors to draw up a codicil to the will, which made the daughters beneficiaries once again to the will. There was a delay in drawing up the codicil, and the father died. So the question was, could the daughter sue the solicitors? Could they said to be a special relationship? And in that case, there was, even though there wasn't a financial statement as such, there was a special relationship there as well. It is possible to claim compensation here for mental distress, damage as a result of mental distress. The case of Farley and Skinner. In that case, the claimant had instructed the defendants, who were surveyors, to conduct a survey of a property. The claimant had said he did not want to be affected by aircraft noise, and did not want to be under the flight path for an airport, because the property was fairly near an airport. In fact, the property was affected by aircraft noise, but the value of that had been taken into account in the price of the property. So the claimant had not suffered any financial loss, but he was able to claim for the mental distress, for the loss of enjoyment of the property that he thought he was going to get. And of course, you've got to bear in mind in this area the Misrepresentation Act 1967, Section 2, subsection 1, which creates damages for the tort of deceit. So it's possible to claim as a result of the tort of deceit. Now I want to move on to another type of restricted situation, and that's called nervous shock, or sometimes referred to as psychiatric injury. Nervous shock, the origins, as you probably gathered, is in Victorian times, and it's a somewhat old-fashioned name. A more modern name is psychiatric injury, but we've got to bear in mind the requirement for a shock, because that will be relevant to some of the cases we look at. We first need to make a distinction between primary victims and secondary victims, and this distinction was drawn by the House of Lords in the case of Page and Smith. The claimant in Page and Smith suffered from chronic fatigue syndrome, which is a very debilitating disease, and is classed by most doctors as a form of depression. Although there is disagreement within the medical profession, it's broadly seen as a form of depression, so a form of psychiatric illness. The claimant was in a minor accident caused by the defendant's negligence. You would not normally have expected too many problems as a result of the accident, but it made the claimant's chronic fatigue syndrome much, much worse, and it made the claimant very ill. Now, because he was in the danger of physical danger, he'd been physically endangered, he was held to be entitled to claim for his psychiatric injury, even though that was greater than you would have expected. Working on the principle you have to take your claimants as you find them, then he was able to claim for his psychiatric injury, even though that was greater than could have been foreseen. But because he was physically endangered, he was able to make a claim. So that's primary victims, but the law imposes many more restrictions when it comes to secondary victims. Someone hasn't feared for their own safety, they feared for the safety of someone else. There, the law is much more restrictive, and a number of differences in the way the law treats primary victims compared to secondary victims. So, for example, primary victims, there are no policy mechanisms to control the number of claimants, whereas we're going to see with secondary victims, there are a lot of policy control mechanisms. So they want to contain liability to a determinate class of people. So don't want it spreading out to an indeterminate class of people, so-called floodgates arguments again. And when it comes to primary victims, all you need to be able to foresee is physical injury. In the case of Page and Smith, he was physically endangered. It was a minor accident, couldn't particularly foresee physical injury, but you could foresee physical injury of some sort, so therefore he could claim for his psychiatric injury. Whereas when it comes to secondary victims, psychiatric injury must be foreseeable. And of course, that rather supposes a very serious accident. You're not really going to anticipate someone being suffering from psychiatric injury if they witness a minor accident. So we're looking at some serious event when it comes to secondary victims. When it comes to primary victims, the issue of foreseeability is considered prospectively. With secondary victims, it's considered retrospectively. So with hindsight, they look at the situation to see whether psychiatric injury could have been foreseen. For the primary victims, they make no distinction between physical and psychiatric injury. With secondary victims, a distinction is made between physical and psychiatric injury because they look at whether a person of normal fortitude would have suffered psychiatric injury. So let's look in detail now at the control mechanisms that are in place for secondary victims. Well, first up, it must be a medically recognised psychiatric condition. So, for example, it could be something like depression, or personality change, or post-traumatic stress disorder. Next, there must be proximity in terms of relationship. Remember, with secondary victims, you're not fearing for your own safety in the way a primary victim is. You're fearing for the safety of someone else. And here we look at the important case of Alcock and Chief Constable of South Yorkshire Police. This was one of many nervous shock cases that arose out of the Hillsborough Football Stadium disaster. The Hillsborough Football Stadium disaster was at an FA Cup semi-final, and what happened was it was terracing, so people were standing to watch the match. In a lane outside the stadium, the police became extremely concerned about the crowd that was gathering there and thought people were going to get crushed. So they just opened the gates of the stadium to relieve the pressure in the adjoining lane, and all they did was shift the problem because everyone moved into the stadium and people were crushed within the stadium, and over 60 people lost their lives through asphyxiation and so on. Now, it was an FA Cup semi-final. It was going out live on TV, so many people were watching. So many people made a claim because they were either in the stadium, another part of the stadium, and they knew they had relatives that were in the affected part of the stadium, or they were watching on television, and they were concerned about people there as well. So the first rule that the Alcock case laid down was that you must be in a close and loving relationship with the accident victim. So you have to be in a close and loving relationship with the accident victim, which will be presumed in a lot of cases, for example, a spouse, but in other relationships you would have to prove you're actually in a close and loving relationship. So, for example, a relationship between siblings, adult siblings particularly, they may be very close or they may not see much of one another. You'd have to prove a close and loving relationship. Now, another thing that was held in Alcock you had to prove was proximity in terms of time and space. You have to be proximate to the accident in terms of time and space. And a number of cases, the case of Boardman and Sanderson, where a father could hear his son being run over. He couldn't see it, but he could hear his son's screams. That was regarded as sufficiently proximate in terms of time and space. The leading case on proximity in terms of time and space is the case of McGoughlin and O'Brien. The facts of McGoughlin and O'Brien were the claimant was at home at the time. Her family, the rest of her family, her husband and children, were involved in a serious accident. Someone came to tell her that her family had been involved in a serious accident. She rushed to the hospital. She saw the family before they'd received medical treatment, and obviously they were in a bad state as a result of being in a serious accident. She saw one of her children die in front of her eyes, and it was held that she was sufficiently proximate in terms of time and space because she'd come across the immediate aftermath of the accident. And the important feature there in the McGoughlin O'Brien case was she was able to take in the full horror of the accident with her own unaided senses. She didn't get some mediated version where someone was telling her, initially she was told, but she saw the full horror of the accident. The nursing staff hadn't had a chance to clean up members of her family involved in a serious accident. They were clearly in a bloody state and so on. So she, with her own unaided senses, took in the full horror of the accident. So if we go back to the Alcock case, do you remember some of the claimants in the Alcock case were watching these events unfolding on live television? Now, could they make a claim for watching on live television? Well, the answer is almost certainly no, because you're getting a mediated version through television. Obviously, there was an editor watching a number of pictures. An editor was deciding which pictures to broadcast. The editor was choosing ones in wide lens, so you couldn't see close-ups of the people who were being suffocated to death. So you weren't perceiving the accident with your own unaided senses. And it would be a very unusual type of situation where you're watching on television, you would take it in with your own unaided senses. It would have to be live television where something happened so suddenly that neither the cameraman nor the editor would have a chance to respond. Then possibly you would have taken it in with your own unaided senses. But of course you'd have to be in a close and loving relationship with the accident victim as well, because we're trying to limit the number of claimants. The law's trying to limit the number of claimants. Now, the idea of immediate aftermath has sort of recently been taken a stage further in the case of Atkinson and Seagal. Here, the claimant rushed to the scene of an accident where a 16-year-old daughter had been killed. She could not get close to the accident because of a police cordon, but she was told by a policeman at the scene that her daughter had been killed, and she immediately went to the mortuary and became hysterical when she saw her dead daughter's body. And that was held in that case to be an uninterrupted sequence of events. This arriving at the scene of the accident, going on to the mortuary, was an uninterrupted sequence. So she was effectively coming across the immediate aftermath of the accident. Now, another requirement is there must be reasonable foreseeability of psychiatric injury. The leading case on this is Boar Hill and Young. The facts of this case was a pregnant woman getting off a tram. While she was alighting from the tram, the other side, and outside of her line of vision, a motorcyclist was involved in a fatal accident. After the tram moved off, she was able to see the blood on the ground, and she suffered a miscarriage. But it was held that she could not bring a claim for psychiatric injury because psychiatric injury could not have been foreseen in that particular case. Now, a psychiatric injury caused by a risk of a future disease would not be regarded as reasonably foreseeable. So we take the Rothwell case, the recent Rothwell case. The claimant here had been negligently exposed to asbestos. Of course, asbestos can cause cancer. He was found to have pleural plaques, which are symptomless. So he was not actually ill, but a certain irregularity was found in his lungs. And this made him clinically depressed. Obviously became convinced he was going to get asbestosis, a form of cancer, became clinically depressed, and it was held in that particular case by the House of Lords that a person of reasonable fortitude would not have suffered psychiatric injury under those circumstances. So his injury was not reasonably foreseeable. Now, the situation with professional rescuers, there was one time it was thought that rescuers could claim, as a matter of course, if they suffered psychiatric injury. And the line of cases more or less starts with the case of Chadwick and British Transport Commission. However, in the Chadwick case, he actually participated in the rescue and went into the area of physical danger himself, which we're going to find is quite important. Because the case of White and Chief Constable South Yorkshire, which was another Hillsborough Football Stadium disaster case, rescue workers at the scene of the accident claimed for their psychiatric injury as a result of being there on that terrible day. And it was held in that case they could only claim if they satisfied all the requirements for secondary victims. It had been thought that because the law wants to promote people as rescuers, wants to promote the idea of a rescue, promote this sort of public spiritedness, that they would not be subject to all these criteria. That was wrong. You must satisfy the criteria for a secondary victim if you're going to claim for your psychiatric injury if you're a professional rescuer, such as a policeman, ambulance driver, paramedic, or firefighter. However, you have to bear in mind, though, employers owe a duty of safety to their employees, so while they might not be able to claim under nervous shock, the employer is under a continuing duty possibly to provide something like counselling to take care of their employees' safety. Now, from its name, nervous shock, it rather implies one single event, whereas it has been held in this case of North Glamorgan NHS Trust and Walters that a series of events could be one drawn-out traumatic experience. The facts of this case, the claimant's baby became ill, it was wrongly diagnosed, the claimant was woken up by her baby having an epileptic fit. The baby was taken off for a liver transplant because it was found to have hepatitis. She was told whilst the liver transplant was being undertaken that the baby would be severely brain damaged even if the liver transplant was successful. Sadly, the baby died. So the question was, had the claimant gone through a traumatic event to claim for nervous shock, or had this been a drawn-out process, so it could not be classified as a traumatic event. But it was held that although it was a long drawn-out process over 36 hours from the initial misdiagnosis to the baby's death, nevertheless it was a single traumatic event. So she was able to claim for psychiatric injury. And that concludes this lecture.